Okay, good afternoon, everybody. My name is Peter Neufeld. I'm a partner at the firm Wagner Sidlowski and the co-chair for this Lunch and Learn series on strategies, advice, and the elderly, along with my colleague, Professor David Friedman. The subtopic that we are going to be speaking about today is with respect to the first meeting and ongoing representation of clients, and specifically assessing issues of undue influence. A paper was prepared by the presenters in advance of today's seminar on this topic, and a link to that paper can be found in the Zoom chat. That'll be available for you to download momentarily. Fortunately, the seminar has also been approved by LawPro for a risk management credit program, and it's eligible for a $50 claim. Please refer to the document also posted in the chat for details on that. No reason not to take advantage of that credit. A big thanks to our sponsors, Scotia Wealth Management, the B'nai B'rith, Concentric Trust, Weir Folds, Donovan Kochman, and Torkin Mains. This event is complimentary because of them. And of course, as always, just a few housekeeping notes. Please have your microphones muted at all times, unless you are asking questions at the end of the presentations, after which we ask that you mute yourself again once you're finished the question. Please also note that this seminar is being recorded. We have three presenters today: Elena Hofstein, Brad Phillips, and Jason Moore. Elena is a lawyer at Miller Thompson. She has practiced in all areas of estate planning, family, business succession planning, corporate reorganization, both pre and post-mortem planning. She advises on cross-border and international matters, wills, trusts, and marriage contracts. Elena is also a recognized leader in charity law, advising both charities and donors on effective legislation, tax and regulatory matters, and on tax-effective charitable giving. She'll be joined by Brad Phillips. Brad is a partner at Wagner Sidlowski. He practices exclusively in the areas of estate litigation, where he is a certified trust and estate practitioner and commercial litigation. And he'll also be joined by Jason Moore, who is an associate at Wagner Sidlowski, practicing also in the estate and commercial litigation groups. If you've enjoyed our seminar, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already. The link for that is in the chat. Cheryl Landy, the Director of Community Engagement of B'nai B'rith Canada, is here with us today. She's going to tell us a bit about the organization and its charitable work. Do you have the floor, Cheryl?
Thanks, Peter. Hello all. My name is Cheryl Landy, and I'm the Director of Community Engagement at B'nai B'rith Canada. For nearly 2 decades, B'nai B'rith Canada has proudly sponsored Wagner Sidlowski's CLE programs. We're grateful for our long-standing relationship with your firm and for the important work that you continue to do in the legal community. As many of you know, B'nai B'rith Canada is recognized as the country's oldest human rights organization. We are dedicated to combating racism and hatred, advocating for the Jewish community, and supporting some of Canada's most vulnerable populations, including the elderly, the isolated, and those living in poverty. Last time I spoke about our weekly food bank for seniors. Today, I want to share another vital part of our work, our affordable housing program for seniors. B'nai B'rith owns and operates 3 affordable housing buildings across the Greater Toronto Area. These buildings offer subsidized apartments, which keep rents affordable and are home to hundreds of seniors. Many of the residents in our buildings came to Canada as refugees or fled countries where they faced discrimination. They arrived seeking safety and dignity, and we are proud to help provide both. Our apartments are more than just places to live. They are communities. Each building includes communal spaces where residents can gather to play games, read, enjoy conversations, or simply relax in the company of friends. Each building also includes a synagogue, offering a space for prayer, tradition, and community outreach. Government support, like old age pension and CPP, rarely increases in meaningful ways, and some of our residents don't qualify at all. For many, our housing is not just affordable, it's essential. These residences foster independence, security, and connection. But more than that, they restore dignity and hope to those who have given much more and now ask for so little. Every senior deserves to live out their years in safety, comfort, and community, and that's exactly what we're committed to delivering every single day. Thank you again for welcoming me and your ongoing support of B'nai B'rith Canada. I look forward to sharing more stories in the months ahead. If you would like to support our work, I invite you to visit bnaibrith.ca/donate. Your contribution helps us to continue providing not just shelter, but community and care for those who need it most.
Thanks, Cheryl. Much appreciated. We're going to start off the presentation now. Elena is going to be the first speaker. Take it away, Elena.
Good afternoon, everybody, and welcome. I'm going to start this discussion by noting that allegations of lack of testamentary capacity and suspicious circumstances surrounding wills are not new. In fact, they've been around for a long time, even centuries. Perhaps the most consequential in the last 500 years had some dire results. The winner of this particular estate dispute became a Queen of England, at least for a short time, and the perpetrator of the undue influence was beheaded. It all started with Henry VIII. Among the many changes that Henry VIII brought about was to give authority to the monarch to unilaterally select his successor. When Henry VIII died in 1547, we know he had many wives. He also had 3 children, Mary, Elizabeth, and Edward. As the sole male child and as the affirmed successor by Henry VIII in his will, Edward ascended to the crown at the ripe old age of 9 years. In 1553, Edward was dying of tuberculosis. He was 15 years of age. Thanks to the machinations of John Dudley, an advisor and regent to the king, King Henry VI prepared a handwritten device, which is like a will, naming Lady Jane Grey's male heirs as his successors. You may not have heard of Lady Jane Grey, but she was Dudley's daughter-in-law. You can see the plot starting to thicken. When it became clear that Lady Jane Grey would have no male heir, when it became clear that Lady Jane Grey would have no male heirs at the time of Edward's death, Dudley caused portions of the device to be crossed out and superimposed the name of Lady Jane Grey herself as the heir. It's not clear if he made the changes or directed the king to make the changes. The original device, including Dudley's directed edits, remain preserved in London at the Inner Temple Library, if you ever happen to want to look at it. The English nobility was very suspicious of Dudley's activities, and it was clear that he had taken advantage of a sick, young, inexperienced king and unduly influenced him to make and change the device to Dudley's benefit. Lady Jane Grey was deposed by Queen Mary and imprisoned 9 days after acceding to the throne. She's therefore known as the 9-Day Queen. Dudley met a little grimmer fate. He was arrested, tried, and beheaded. Fortunately, parties to modern estate litigation do not risk such macabre outcomes as that suffered by Lord Dudley, luckily. Nevertheless, many of the principles underlying the Lady Grey case have become enshrined in jurisprudence that continues to be relevant today. So this presentation and the accompanying paper will provide a brief overview of the law of undue influence and suspicious circumstances, and will review how these concepts are applied both in the context of a will challenge and a challenge to the validity of a power of attorney. So I'll start by giving a broad overview of undue influence. In the 1998 case of Banton and Banton, the court set out a modern approach of undue influence as it applies to testamentary documents, and noted that a court will set aside a will if it is established on the balance of probabilities that influence was imposed on the deceased, and that influence was so great and overpowering that it did not reflect the will of the deceased, but rather reflected the will of the influencer. The court will look at whether the potential for domination was inherent in the relationship between the parties. The court also made clear that it isn't enough that the beneficiary had motive and opportunity to unduly influence the deceased, but it has to be shown that the party actually exerted power to the extent that the will would not exist in its current form, but for that coercion. In the Scott and Cousins case, which quoted the 1885 decision of Wingrove versus Wingrove, the court said the following: to be undue influence in the eyes of the law, there must be, to sum it up in a word, coercion. It must not be a case in which a person has been induced by a strong relationship to come to a conclusion that he or she will make a will in a particular person's favor, because if the testator has only been persuaded or induced by considerations which you might condemn, really and truly to intend to give his property to another, though you may disapprove of the act, yet it is strictly legitimate and in the sense of being legal. It's only when the will of the person who becomes a testator is coerced into doing that which he or she doesn't desire to do that it is undue influence. And with that, I'll hand it over to Jason, who's going to talk about undue influence in suspicious circumstances in will challenges and in power of attorney disputes. So over to you, Jason.
Thank you very much, Elena. So as Elena mentioned, very closely related to the concept of undue influence is a concept known in Ontario as suspicious circumstances. Those are the magic words. So the individual who seeks to propound a will, so to uphold its validity, has the legal burden of proof on a balance of probabilities as the civil standard. In other words, the person seeking to uphold the will must prove that it was properly executed and that it was done so with the knowledge and approval of the testator, while that testator had testamentary capacity. And when they do so, they are assisted by a presumption at law that a will that was properly executed is presumed to be valid. So what does an attacker do at this point? Well, they adduce evidence of suspicious circumstances. And once they have done so, that presumption that it was duly executed is rebutted, and the attacker and propounder of a will then adduce evidence to prove or refute, respectively, that these suspicious circumstances resulted in the will being produced as a result of the undue influence. So from a legal standpoint, it is important to note that introducing evidence of suspicious circumstances does not shift the burden of proof to the propounder of the will in the will challenge proceeding. It only means that the presumption of validity has been rebutted. And this was made clear in the Supreme Court decision of Vout and Hay. So as of right now in Ontario, the attacker of the will always has the burden of proof to invalidate that will. So what are some examples of suspicious circumstances? Well, there's no exhaustive list, but there are three commonly cited categories of suspicious circumstances. And the first is an elderly testator, especially one who is not known to the drafting lawyer, comes and asks to make a new will. And the second is a testator who has suffered significant ill health, and particularly if the condition affects the mental abilities of the testator, wants to make a new will. And the third is a significant change to testamentary plans that are made. And these changes typically end up excluding or significantly diminishing a bequest to a close family member, especially one who had been a main beneficiary under a previous will. So Brad and I recently represented the propounder of a will in a trial that dealt with these issues. And in the judge's decision, His Honor noted some very illustrative examples of these suspicious circumstances. So the judge noted that the testator was in a relationship of dominance with the propounder. That's a very common example. So for instance, they lived together. The testator was somewhat isolated while living with the propounder of the will. And the propounder set up and selected the appointments with the drafting solicitor. The propounder communicated with the drafting solicitor on the testator's behalf. The propounder also accompanied the testator to the hospital where the testator ultimately executed her will very shortly before her death. So the judge cited these as suspicious circumstances. But the judge contrasted this with other evidence to ultimately find that the suspicious circumstances did not rise to the level that the testator's free will had been overborne. The judge cited evidence such as the copious notes taken by the drafting solicitor, which showed that the testator had given competent instructions with supporting reasons during previous consultation meetings. He also relied on the testimony of law clerks who witnessed the will as it was executed to determine that the testator had capacity. And drafting solicitors should take note here. Taking clear, contemporaneous, and copious notes is crucial, as they will very likely be key evidence in any proceeding in which a will is challenged. And the court will very likely turn to these notes to determine whether the testator had capacity and to look for evidence of undue influence by others. Now, there are specific nuances that apply to litigating issues of undue influence in attorneyship disputes. And this is because, unlike in will disputes, the vulnerable person is still alive and can very often speak to their own testamentary wishes. And to speak further to this issue and to discuss some case law, I'm going to hand it back to Elena.
So I'm going to talk to you about the Vanier case, which is a case where there was an attack on the validity of a power of attorney. So the Ontario Court of Appeal considered this the situation in 2017, and it provides insights into how a test for undue influence and suspicious circumstances apply in cases of impugned powers of attorney. So Raymond and Pierre are two sons of Rita. Rita had built up wealth during her lifetime, and at the ripe old age of 90 years, needed access to those funds to support her expenses. In 2013, she appointed her twin sons jointly and severally as her powers of attorney for property. The brothers grew suspicious of each other, of how they were each handling Rita's finances. So one of the twins, Ray, began to take steps to obstruct Pierre, the other twin's, ability to manage her finances. And as a result, Rita was not able to meet her rent in the care home that she lived in. In 2015, Rita signed a new power of attorney in favor of Pierre. Ray was not happy, and he challenged this, including arranging for a capacity assessment. Capacity assessor found she had capacity to execute and to revoke a power of attorney. Not satisfied with that, Raymond then challenged the power of attorney in court. He lost at trial, and he appealed that decision. In the appeal, he argued that the proper test for challenging the validity of a power of attorney situation is different from a test for undue influence in a will challenge. Basically, his argument was that the proper test was the application of the inter vivos equitable undue influence, and where there are suspicious circumstances, then the burden of proof with respect to the capacity shifts to the grantee of the power. Put another way, Pierre's dominance over Rita triggered the presumption of undue influence, and since he failed to lead evidence to rebut that presumption, the 2015 power of attorney should be set aside, he argued. The court rejected these submissions. With respect to the equitable inter vivos undue influence argument, the court noted that it had not been raised initially, and in any event, had no application to the facts in this case. In order to shift the burden of proof, it had to be shown that the transaction was not readily explicable by the relationship of the parties, and the transaction was immoderate and irrational. The court found that Rita's decision to give the power of attorney to one son over the other was emotionally difficult but totally rational. She knew the money was out of reach, that she needed money for basic expenses, and that Raymond was interfering with his access to the funds, and the solution lay with Pierre. The court also found that there was insufficient evidence to interfere with the factual finding of the motions judge that the evidence didn't establish suspicious circumstances. The result is that there is no Court of Appeal decision from Ontario that has extensively looked at broader question of how suspicious circumstances should or should not interplay with undue influence claims involving validity of powers of attorney, and the lower courts have applied the same tests or undue influence and will challenges and powers of attorney challenges. I'm going to hand it over to you, Brad.
Thanks, Elena. So I'm going to now talk about the case of Druniak and Smith, which is a Court of Appeal decision from Manitoba. And essentially, the Manitoba Court of Appeal, 7 years post-Vanier, boldly went where the Ontario Court of Appeal chose not to go. And specifically, whereas the Ontario Court of Appeal, as Elena just mentioned, in Vanier elected not to decide whether inter vivos equitable undue influence should be applied in the context of POA challenges, rather than the testamentary undue influence test, the Manitoba Court of Appeal did in fact undertake that analysis. And although this is far beyond my pay grade, if you ever review those cases, you'll note that the only distinguishing factor between what the Court of Appeal in Vanier looked at versus what the Court of Appeal in Druniak looked at in Manitoba is that whereas the Court of Appeal in Ontario called it inter vivos equitable undue influence, in Manitoba they called it equitable undue influence. And whereas in Ontario they called it the testamentary undue influence, they refer to that same exact legal analysis as probate undue influence. But beyond looking at those two concepts, the Court of Appeal in Manitoba also helpfully drew a distinction between the two meanings of the phrase burden of proof and how that was being applied or referred to in probate proceedings generally. So specifically, the court identified that in the case law, burden of proof seemed to be used in two distinct ways. It could be used as a reference to the persuasive legal burden, which is the onus to prove the facts on the civil standard of the balance of probabilities, or it had been used to apply to the concept of an evidential burden, where a party must point to a minimal threshold of evidence before an issue is even addressed by the court. And distinguishing between those two types of burden of proof was important for what followed in the Court of Appeal of Manitoba's analysis. And that is because the court again noted that in probate proceedings, aka will challenges, an evidentiary presumption of undue influence does not arise. And that's clear from Vaudenhay and earlier Supreme Court of Canada decisions. However, when you're considering the evidential burden in equitable undue influence claims, the Manitoba Court of Appeal concluded that an evidentiary presumption of undue influence can exist if certain facts are established, which can assist the party challenging a transaction in satisfying their persuasive legal burden to prove undue influence. So then the Manitoba Court of Appeal then went on to consider whether powers of attorneys were closer to testamentary documents or other documents, such as contracts, that applied the equitable undue influence test, and ultimately it concluded as follows. It said that the test for equitable undue influence should be applied in the context of challenges to the validity of a POA, in contrast to the manner in which that applies in a case of a will challenge. So as a result, the evidentiary presumption of undue influence arises requiring the challenger of the POA to first establish that the grantor and the grantee of the POA were in a relationship with the potential for dominance, and that the granting of the power of attorney was immoderate or irrational. So summarizing in another way, Druniak can be summarized as follows. First, as stated by the Supreme Court of Canada in Vaudenhay, the challenger of the POA always has the legal persuasive burden to prove that the POA is invalid in an undue influence scenario. But, at least in Manitoba, if the challenger introduces sufficient evidence, to establish certain specific, what I'll call suspicious circumstances, i.e. that the relationship was one of dominance and that the granting of the POA was immoderate or irrational, then the presumption of undue influence applies and the evidentiary burden shifts to the propounder of the POA. So the practical effect of this is that the evidentiary shift is to make it somewhat easier for the challenger to argue that the POA is invalid, although the legal persuasive burden still remains with the challenger of the POA. And essentially then, once the challenger has met this test of establishing these specific suspicious circumstances, the onus then shifts, the evidentiary onus then shifts on the propounder of the POA to rebut the presumption, the evidentiary presumption of undue influence. But ultimately, even with all of that, the person challenging the POA still ultimately has the legal persuasive burden to prove that the POA is invalid. So that is a shift from the way that the lower courts in Ontario have dealt with challenges to POAs on the basis of undue influence to date. And notably, Druniak has not yet been adopted in any Ontario court rulings. And in fact, the decision is so recent that it hasn't even been referenced in any reported decisions in Ontario as of today's date. So it remains to be seen whether the Ontario courts will adopt a similar approach. And more than likely, this is an issue that's ultimately going to have to be dealt with by the Ontario Court of Appeal. So now I'm briefly going to move on to sort of some of the more practical realities in dealing with undue influence, both from the perspective of the drafting solicitor and why it's so significant to litigators as well. And Jason actually touched upon some of this earlier, but I'm going to go through it in a little bit more detail now. So in their malpractice claims fact sheet, LawPro has stated that malpractice claims in wills and estates practice have increased steadily over the last decade, nearly doubling in frequency. And the heightened increase in claim arises from the significant onus placed on drafting lawyers who prepare wills and POAs, which can easily embroil them in litigation, either as a witness or, worse for them, a party. And while a lawyer can never totally eliminate these risks, some fundamental practice habits can assist in reducing these types of scenarios. And it starts from the reason why drafting lawyers find themselves involved in this manner is because the case law makes it clear that a drafting solicitor of a will or a POA has an obligation to both assess a client's testamentary capacity and whether he or she may be subject to undue influence. And because our discussion today is really focused on undue influence, I'm really going to limit the sort of red flags or suspicious circumstances that heighten a lawyer's duty to investigate undue influence specifically. And as alluded to, Jason alluded to earlier, some of the classic scenarios of or concerning or red flags are where there's an elderly testator involved, particularly one that's not known to the drafting lawyer, or a testator who's suffered significant ill health. And then the other major red flag is a situation where there's the involvement of a beneficiary in the preparation of the will and or the person who is being named as the attorney for property for care or for property or care, I should say. And typically that would involve, for example, that the person is the person who's going to be the beneficiary and or is going to be named as the attorney is the one who made the call with the lawyer who drives the elderly client to the lawyer, etc. So when you're faced with these types of scenarios, the drafting lawyer must ask probing questions of their client to assess whether they may be subject to undue influence. And Jason will be talking about some of those recommended types of questions later in the seminar. But as a lawyer who's done law pro work for 20 years, I can tell you that even if a lawyer asks their clients a series of wonderfully probing questions, if you don't take detailed contemporaneous notes, it basically renders your efforts as being pointless. Because 9 times out of 10, if there is an absence of contemporaneous notes or the note-taking is deficient, a court is just not going to accept the lawyer did in fact ask these questions. They're going to assume that a reasonably prudent lawyer would have taken such notes when asking those questions, And therefore, if there are no notes or insufficient notes, they're going to assume that those questions were not, in fact, addressed or asked. And moreover, for a lawyer's perspective, if they're ever called into an action and have to give evidence, trying to specifically recall a meeting that happened 3, 4, 5, 6 years earlier, or even more, without having the ability to refresh your memory from notes is needless to say, challenging. So it's really what the real test should be, is that you have to ask these probing questions and you have to take detailed notes of both the questions and the responses you receive, because it is this contemporaneous record keeping that will be critical in a will challenge case or a challenge to a POA, and may also serve to protect the drafting lawyer from being added as a party to the proceeding rather than just being a witness. And Jason touched upon this earlier, and I'll let him comment again regarding what I view as being the key fact in a case where there were suspicious circumstances. What was critical in terms of how the court ultimately determined whether a will, in this case, was valid or not, hinged on note-taking. So, Jason, I'm going to pass the baton over to you so you can talk a little bit more about that, and also about some of the types of questions that, in particular, a drafting lawyer would be well advised to ask and make notes of when they have some concerns that undue influence could be a potential issue.
Thanks, Brad. So as Brad said, given the real possibility that a drafting lawyer may be held liable to a third-party beneficiary, there are generally some practical steps a lawyer should take, and I would say need to take, to reduce their potential exposure to liability, and also just make a better witness in the event that a will challenge is brought and they're called up as a witness. So the first step is to appreciate the context of the situation. I touched on this earlier. Where suspicious circumstances are present, the lawyer's duties to investigate capacity are heightened. And in the face of these suspicious circumstances, a lawyer is required to make searching inquiries into their client's capacity. Now, once they've done that, the second step is to maintain, as Brad said, and as I'm going to emphasize again, even if it sounds like a broken record, detailed notes to substantiate findings regarding testamentary capacity and undue influence. Many lawyers take handwritten notes using a pen. I know some now take it on their computer. Many computer programs date stamp edits to a specific document, so you can tell when those notes were made and if they've been edited since. But take notes not just about what your client says about their testamentary wishes. That's just step one. You should also take notes about their comments, about their family, about their reactions to any testamentary planning proposals or suggestions that you make. Maybe they maybe they really don't like a particular suggestion when you say, what do you want to leave this particular beneficiary? Also note who else is in the room. This is crucial. And that person's relationship to the testator and what they have to say. Maybe they're also interpreting for the testator if the testator isn't particularly strong in English. That creates a communication barrier you have to watch out for. Are they feeding information to the testator, or are they encouraging specific responses? Sometimes what you'll see with a particularly incapacitated a testator who lacks capacity is they will just nod to answers or suggestions, and someone in the room with them will be nodding and encouraging them to agree to certain proposals. And it's crucial that you take note of that. So compelling note-taking may greatly assist in the estate in opposing a will challenge. And obviously, if a will challenge is ultimately not successful, that greatly reduces the likelihood that the drafting lawyer will be vulnerable to claims of negligence. And a key part of this is creating and using checklists. And that really is a critical step in discharging these duties. And in a very useful article by Stanley Rule, the author offered the following advice, which I'll just state here in full. Conduct a thorough interview of your client without the presence of family members or others who may anticipate to benefit from your client. This advice applies to whether your client is contemplating making a will, settling a trust, or making a large gift during their lifetime. There is no substitute for a thorough interview. You may, of course, recommend that your client be assessed by a psychiatrist, a psychologist, a capacity assessor, or other healthcare professional. But such a referral should be in addition to conducting your own interview. Ultimately, in cases of doubt, the onus will be on you to decide whether to go ahead with the will or other document or transaction. You cannot delegate this. Ultimately, if the document or transaction is challenged, you may have to tell the court what questions you asked, how your client responded, and what advice you gave your client. You cannot delegate this either. So in the paper that we published that's a companion to this seminar, we offer a series of example checklists that are not intended to be exhaustive, that offer a good starting point to make checklists of your own. Questions such as, did any family members bring you to this meeting today? Did they assist you in finding us? What is the nature of your relationship to the person who brought you here? How long have you known them? Do you live with any family members? If so, who and for how long? Do you receive any assistance in respect to your personal health care and finances? If so, from whom? Have you recently made any gifts? If so, in what amount, to whom, and what was the timing of such gifts? When was the last time you updated your will or POA? Is there a reason you did not go back to the same lawyer who previously prepared your previous testamentary instruments? This is crucial if they're being brought to you for the first time and they have previous wills that are made by a different lawyer, especially if you have a relationship with the person who brought the prospective testator to you. Prior to your last update, when did you previously prepare your will or power of attorney? Do you intend to include the people who brought you here in a will or name them in your POA? Is there any conflict within your family? And if the client proposes to modify a will to benefit a specific person or to modify an existing POA, it's crucial that you ask, is this person aware that you want to make changes to your will or power of attorney? Did you discuss this with them before you came in today? Have you had more than one discussion with this person, and why? Why did you want to change your will to the benefit of this specific person? And why do you want to reduce or disinherit previous parties named in your earlier wills? And these questions are a really good way to discharge your professional obligations and ensure that you're making absolutely certain, to the best of your ability, that the notes that you're taking and that the will you're preparing reflects the wishes of that testator and not of some other person who's attempting to influence them into making a will or other bequest to their benefit. So thank you very much. And with that, I'll turn it back to Peter.
Great. Thank you, everybody, for presenting on that really interesting and informative topic. Now we'll open up the floor for questions. One question I see in the chat, and again, you're welcome to just chime in and say the question orally. That's fine. We're in an informal setting here. But one question that was noted was whether notes should be in writing or if they should be typed when taking proper notes to avoid any claims of undue influence in the future. Personally, my preference is that typed notes are actually really helpful these days because you have systems such as Google Docs, for instance, that in real time will see when you are taking those notes. So that will avoid any claim that you took notes at a later date, for instance, when you discovered there might be a claim for negligence against you. It will show the actual timestamp to say how long after that meeting with the individual those notes were taken. And often they will show that they were contemporaneous with the meeting itself. So my preference on that is typed. But Jason, you were speaking about note taking. I don't know if you have anything to add on that.
Yeah, I do actually. And I think that's a good question. I know when I'm speaking to specifically probably the younger lawyers in this meeting right now, just to be clear, like myself, oftentimes I found in law school and as a young lawyer, it's difficult because we're not trained to take notes by hand quite as rigorously, that handwriting isn't always as clear, or your hand gets tired and you can't take notes for as long. These meetings can go on for quite some time. And if you find it easier to take notes typed, and you're using a program that timestamps them to show, like Peter said, that they were taken contemporaneously, that can be a good way to ensure that your notes are usable and authentic by not just yourself, but also your staff. Maybe you're delegating the actual drafting to a student or a younger lawyer or a clerk. That's useful for them. It's easier than just deciphering your handwriting. And when it's ultimately put before a court, it can be much clearer than the difficult to read handwritten notes that would have been taken a while ago if your handwriting is not quite up to snuff. And I know if I'm speaking from experience here, I know that mine is not. So that's how I would answer that question.
So I'm going to just jump in, Peter, on behalf of older lawyers, or those who are less tech savvy. I don't think if your practice is to take good detailed notes by hand and your notes are legible, I don't see that there's any real concern. Yes, there is some advantage in doing it in typing because you can obviously have a digital date stamp as to when you prepare the notes. But presumably, if you're going to be a witness and you're a lawyer and you've dated the, handwritten a note with a date on it, and a court, 9 times out of 99% of the time is going to accept that your notes were prepared contemporaneously. So to me, the real key issues are, is it legible? And does it let you take detailed notes? Because even if you have a meeting and you take sporadic notes that aren't clear and are hard to follow, that's not really going to help you. So if it's easier for you to write in detail and make detailed notes by that practice, I'm not really concerned about it. Often what ends up happening is that a lawyer will also, if they're ultimately named as a witness, they'll prepare a typed version, reading out exactly what their previously handwritten note says, which makes it easier for all of the lawyers participating to understand the handwriting, etc. So I don't think there's a hard and fast rule, but the main thing to note is it should be clearly dated, and it should be detailed. And going back to the case that we dealt with, there were issues with the manner in which the lawyer ultimately had the will executed. Frankly, it wasn't done in an ideal way, and the court made note of that. But the saving grace of what the lawyer did and why her evidence became so critical was because during a meeting where she met alone with the testator, she took 9 pages of handwritten notes, and it addressed and clearly addressed and legibly addressed many of the issues that became issues at the trial. And because of that, that really obviously appears to have been the key to the court in making its determination, notwithstanding the fact that there were some problematic manner in which the will was actually ultimately executed. So I think it just drives home the point that as long as it's detailed, and these were handwritten notes, as long as it's detailed and dated and addresses the issues, I think you're okay either way, what other way you're comfortable with.
If I could add something as a more senior lawyer than you, Brad, and you, Jason, and being a drafting lawyer myself, these messages really resonate with me. And I've had a number of situations where, it's been a problematic meeting. I have taken other lawyers with me. Sometimes when it's really problematic, I try and take a lawyer from another firm so that, there are 2 of us who are looking and listening to the same thing and also taking copious notes. The other thing I've learned over the years working with people like Brad and Jason who, litigate rather than me, who creates rather than litigates, is that I also take copious notes of the surroundings, not just what is said. And as you said, Jason, the expressions that the testator uses in responding to questions, but also what were the surroundings of the room? Where was the testator? Where were we sitting? And so on. I find that has helped as well.
Perfect. Great. And on that note, there's sort of a subsequent question here about notes. What if the drafting lawyer is not being cooperative in releasing their notes? You need these notes to prove undue influence, but the lawyer doesn't want to fork it over. I mean, my opinion on that, again, as the one who litigates and doesn't create, is you bring a motion and you have to compel the production of those solicitor notes. It is becoming more difficult now to satisfy the test to get those documents, but the only other way I would say you could get those notes is if everyone, including the executor, consented to the release. And even then, if a lawyer has something to hide, they're often going to say, I'm not going to produce anything without a court order. I don't know if any of the panelists have anything to add to that.
Yeah, I'd like to add a couple of things, and one is that, and some drafting lawyers don't necessarily know this because fortunately they may not have ever been in this scenario, but it's even if you are only going to be a witness, it is a practical and good idea to let Law Pro know, because Law Pro will actually assign a lawyer to help you deal with the ultimate production of the file. Because as Peter said, the reality is if there's any kind of validity to a potential will challenge or a challenge to a POA, those records will ultimately be produced and you are ultimately going to be a witness. And so having a lawyer at Law Pro who's dealt with these types of files is also helpful. And they can address if there are concerns, if there's reasons behind why you don't want to, they don't, or the lawyer doesn't want to voluntarily disclose it. The lawyer for Law Pro may be the one who can say, yeah, I don't think that's a proper ground, or what we can do is we'll redact this one paragraph if you're concerned about it, and we'll let, they can bring a motion if they need to argue that they should have access to that specific note. So the short answer is ultimately you could bring a motion, but practically speaking, a lawyer really shouldn't be. A lawyer should contact Law Pro because Law Pro might say, we have no problem producing you these things if all the beneficiaries agree to it, and or they're going to say, as long as you get an order, no problem. So it's often a helpful way for everybody really for Law Pro to be involved. It's helpful for the drafting lawyer, and it's also helpful, frankly, for the litigators because we've all been dealing with these types of scenarios before.
Perfect. There's a sort of a practical question here or a hypothetical that's given, and I'll just try to summarize the question. Essentially, there is a potential client that was referred to a lawyer. That potential client lives in the United States, and the person who referred that client was a previous client of the lawyer. They're sisters, in fact. So sister refers her sister to her existing lawyer to say, go to this lawyer, prepare a power of attorney. And then the question is, and I guess this is sort of around the idea of, are there issues of undue influence here? Would it be professionally inappropriate, or are there concerns by accepting that referral from a previous client or an existing client to prepare their sister's power of attorney? I mean, my answer to that would be no. I don't see an issue with that. You get these referrals on goodwill, but of course, you need to be alert to undue influence anyway. Is that person going to be wants to sit in the same room when the powers of attorney are being prepared? Who's actually giving the instructions? So that, you need to be aware of the situations that Jason has set out. But the mere fact that there's a referral from a previous client, even if a client is being appointed as the attorney for property and personal care, I don't see that as being, a disqualifying situation. I hope I communicated that question clearly. I don't know if any of the panelists have any comments to it. All right.
I'm happy to jump in. I mean, I agree with you, Peter. On its face, there's certainly nothing at first instance that would raise any kind of alarm bells. Ultimately, it's going to be about there's lots of facts in that scenario that we don't know about. So for example, if you still have to ask those probing questions, is that sister who referred the other sister intended to be the power of attorney for property and care? And then you're going to have to make, were any gifts, did that sister receive any gifts of any large portion recently? anything that would set off alarm bells. So it's not, there's certainly on its face, there's nothing inherently concerning about that. But ultimately, that's really exactly why those types of questions need to be asked, is because it may only, or your concerns may only arise in the context of asking these important follow-up questions, that then you might have some alarm bells. But on its face, just because you get a referral from one sibling to another to help another sibling out, I definitely don't see that as being a concern.
There's another question here. The question is, would an affidavit of execution prove the absence of undue influence? So a will is being prepared, the lawyer signs the standard affidavit of execution. Is that enough? Ellen, I see you shaking your head. Is that enough to say that there is no undue influence?
All the affidavit says is that, notes that this is the copy, this is, an affidavit of execution that they were present. It doesn't go to the issue of undue influence or any of the things that Bradley and Jason were discussing. It doesn't satisfy the test. So no, I don't think it adds any value or not much. Now, Brad and Jason are going to disagree with me, right?
No, I'm not disagreeing with you. I 100% agree that
I'm running scared here with all these litigators, you can tell, right?
no, that's correct. All that does is it confirms that, it was duly signed. It doesn't answer the questions surrounding why was it signed, how did it come to be signed, who made the decisions about how certain bequests were made. It doesn't address sort of the fundamental issues that you have to be concerned about when there's issues of undue influence. Obviously, it always helps that undue influence cases are always difficult to prove, and certainly if a lawyer is involved in the drafting, that generally is a leg up in propounding that will, but that's no guarantee just because a lawyer is involved that there's no chance that the issues of undue influence cannot arise.
All right, we've got time for one more question here. This is an interesting one about joint retainers. You have a situation where spouses come in, they want their wills prepared. In this case, they're calling them, there's a mutual intention to appoint each other as each other's estate trustees, as their attorneys for property and personal care. Are there any safeguards that you think the drafting lawyer should implement to avoid a situation of undue influence? Perhaps one spouse is unduly influencing the other to prepare those powers of attorney or to prepare a will in accordance with the other spouse's wishes.
Now, I'd be curious to know if you do anything differently in those types of scenarios on the drafting side.
I've just been thinking about that. That's an interesting question. If the clients are known to you, it's a little easier to ascertain whether there is undue influence being put on one spouse by the other spouse, especially if it's in a second marriage situation and there's a dramatic change to the instructions. Yeah, I get suspicious, and the reality is I probably have to send both spouses away because my retainer has been joint, so I don't think I can act for either of them separately in those situations. So that's sort of a preliminary response. Yeah, those are tough situations.
There's another, I said there was only one question left, but there is another question here that I think is really important for today. When a meeting is virtual, how do you avoid a situation where there might be undue influence? There might be someone outside of the camera's view that is coercing the individual to give, specific answers. How do you avoid that?
That's a good question. And my answer would be, if you have sort of on its face going into that type of a call, sort of some of those red flags. So that virtual meeting was set up by a one child of the deceased, of the testator, excuse me, and the client is elderly. And then you find out during the course of the meeting, or even prior that, there was a will prepared a couple of years ago with a different lawyer, and you now understand, and then are told during this meeting, virtual meeting, that the kid who set up this meeting with you just happens to be the person who's going to become the primary beneficiary of the estate. I think in that scenario, you actually cannot continue doing it virtually. I think you actually have to say, I'm only going to take the retainer if I get an opportunity to meet with the testator alone privately and satisfy myself with the concerns I have, because I agree, in that kind of scenario, there are legitimate concerns about somebody being in the room and potentially coaching them while you're having the meeting going on. And I also appreciate that, some drafting solicitors, they're doing these type of will preparations for minimal fees. And then you really do have to ask yourself, is it worth the business to risk what could potentially be an outcome? And, in my view, those types of scenarios, it's not worth the risk. Either you're going to have to say, I'm going to charge you more and meet in person, or you might ultimately say, you have concerns and elect not to deal with the file.
Great. Thank you very much for that. Okay, that's all the time we have. I know there were some additional questions, but we're gonna end it here. Thank you everyone for participating. Thank you very much to our panelists for giving a great presentation. On June 24th, that'll be our next presentation. It's an important one. It's about comparing the different thresholds of capacity. If you've been following these seminars to date, you know that there are different levels of capacity that need to be assessed, and we hope that this next seminar will, be able to compare and contrast those different thresholds to hopefully better educate you on, what is the capacity, for instance, to prepare a power of attorney versus the capacity to manage your own property or prepare a will or make a gift or enter into a contract. Also, a special shout out to Elder Law Day. That's going to be happening on June 19th. It covers a lot of the topics that we've discussed today. So if you're interested in that, that's with the OBA. I encourage you to sign up. As a final reminder, the link to the B'nai B'rith Canada can also be found in this chat in case you would like to donate. Thank you all again for attending, and we look forward to seeing you in a couple weeks.